Well, good afternoon, everyone. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels. We'll be getting to the JRC here in a moment, but first, I'm going to tell you a little bit about this crazy day. And, of course, we'll go through the disclaimers and the trigger warnings as per normal. So, right in the middle, and I do mean literally, right in the middle of my usual 3 to 4 hour morning workout routine. Just right after I had gotten off having done my second set of the day on the climber. All trigger alert, we curse on this channel, all hell had apparently decided to break loose. So, I'm no strangers to the tornado sirens blaring around here. In fact, it's literally a thing out here where if you have childhood memories of going Easter egg hunting with the tornado sirens blaring, I have a few of those. Yeah. It's usually not a big deal and they jump all right over Springfield, but today was not that day. It touched down on a Kansas Expressway, and it headed up a little bit up towards the mall, and though the storm didn't come here to where our buildings are in this little part of the city here, just the wind by itself uprooted this massive, really old tree that sits right there next to the mailboxes, completely out of the ground, and just fell over. It's like blocking half of the street and then up and onto the curb and just barely misses touching the mailboxes. To the point that there's two street signs that usually sit there next to that tree that are still standing between the branches of the fallen tree. And it's not just that. So when that was happening, almost the entirety of our whole state was hit this morning. Literally the only place that did not have a tornado touch down was in the Bookhel area of Missouri. But wait, there's more. We are going to be in it again starting around 9 p.m. So, we better get these videos going here. And don't worry, folks. We're safe. Nothing happened to the apartment. Me and the Mr. Big Kitty over there essentially grabbed my very thick cushioned, very large pillow and went into the bathroom, which is in the center of the apartment where there's no windows or anything, and we kind of just waited it out in there. Alright. To the disclaimers. If you're unfamiliar with the Stop the Shops campaign or the campaign against the troubled teen industry, pertinent links are going to be there in the description box for you. In particular, please note that we always have linked in there Autistic Hoya's massive archive on the subject. Now, they've got everything from court transcripts to what happened out in California when the JRC was still known as the BRI, or Behavioral Research Institute, what got them kicked out of Rhode Island. And yet, we have documentation in regards to this school's atrocities, including the 6 kids dead because of them, all over that archive. It's definitely a good link. It is very thorough. And yes, we even cover the other side. We have links for the testimonies from parents who are on the side of the JRC and the think pieces that were on their side, and even the JRC's bizarre, migraine-inducing, horrific excuses of a so-called clinical study. So, if you want to take a look, get a better, more thorough idea of what's going on in places like that, that is going to be one of your best stops. We also have linked in there the article by Neuroclastic, where they surveyed over 800 ABA professionals in regards to the JRC's so-called behavior modification program. In fact, the JRC threatened Neuroclastic with a defamation lawsuit over that particular article if Neuroclastic would not remove said article from their website. Very obviously, Neuroclastic refused, so please read it. Share it on all your social media as well. Also, we have linked in there the GoFundMe that was set up on the behalf of Neuroclastic in case the JRC ever does see through with their threat, because unlike them, we do not have access to unlimited sums of money. More's the pity. Because if you ever want to see just how fast I'd be getting the hell out of here if I had access to that kind of capital. Just saying. I wouldn't wait or hesitate. Alright. Now, trigger warnings. When we discuss places like the Judge Rotenberg Educational Center or Agape Boarding School for Boys, you're going to hear vivid descriptions of and catch clips or surveillance footage of people with mental health issues and disabled people being tortured and abused. If you got young children present, go ahead, utilize the headphones. Also, the channel is marked not for kids for a reason. We use profanity and speak on dark subjects. If your child's 16 and younger and they are watching this, parental supervision is advised. Now, folks, we are about to read once more the stupid that is known as the JRC trying to defend themselves very poorly. So just be prepared for the stupid. Maybe take some Tylenol first. Alright, so, back where we left off the other day. Although the FDA purports to be engaged in simple rulemaking, labeling as such does not excuse the agency from the basic requirements of a judiciary procedure when the agency action at issue boils down to individualized decisions applicable to a few persons based on findings particular to those persons. You really don't get it, do you, JRC? You really don't understand. I'm going to try to explain it again to you. Okay? If the individualized decisions that are being made on the behalf of these minors are going to cause them to be at extreme risk of physical or psychological harm, or in a case in regards to this device, literally all of the above, then whether you like it or not, federal departments and state departments have the right to intervene in regards to that decision making. It's not complicated. You're trying to put them on a device that has been known already to cause second and third degree burns, has caused one individual very infamously and in particular to go into a 2-month catatonic stupor. You have numerous former students coming forward explaining that where the electrodes were attached to them, in some of those areas, they no longer have feeling in them. You have ER documentation of Andre McCollins, the two individuals that were woken up in the middle of the night and shot on a 4-point down board, face down, just like Andre, with noise-canceling helmets, 71 times each. We have not just those documents, but also the ER photos of the injuries caused by your devices. We have the individuals who came forward with their testimonies in regards to what you did to them. And JRC, allow me to say this to you again for the billionth time. The reason why their testimonies were given more weight than the Kool-Aid drinking parents that you brought forward to testify on your behalf is the individuals who spoke against you came packing receipts. Which means all the evidence that we have on hand corroborates everything that they said when speaking with the panel. So, the parents who testified on your behalf has their own opinions and observations. They do not have any type of medical documentation whatsoever to back up their claims. Therefore, the folks who spoke against you are going to be more believed because they came with receipts. What is there not to get here? None of the parents you brought forward brought receipts. Not even that see-through as glass appeal to authority with the primary care physician of one of the students there and him saying, well, obviously he's a doctor. He knows best. He's a primary care physician. He's the individual we go to when doing yearly checkups. Right? He's the kind of dude we go to if we break an arm or a leg. We get like little stomach issues. He's not an expert that has ever worked inside this field. Which means his so-called opinions on the matter are completely and utterly irrelevant to the conversation at hand. Not to mention, I find it like very, very, very much red flaggy that this is a primary care physician who is waving away the fact that these devices have already caused other students second and third degree burns. As a primary care physician, you sometimes have to deal with individuals who come in with those types of injuries. If you know that you know that you know, which we very obviously do, we have the ER documentation that those devices at the very least cause those types of injuries, and you're still gung-ho and testifying on its behalf and advocating for it, you should probably have your license as a primary care physician to be yanked. I mean, I'm just saying. That kind of has, like, literally all the red flags. All of them. All of them. You are a primary care physician. Your job is for individuals who come in with those types of injuries on occasion to treat them. You know that you know that you know that that device has caused second and third degree burns. To still be going, but it's still better than you doing it yourself because it's a direct care staff that is abusing you, like, bro, you have no business being anywhere whatsoever within any type of medical practice whatsoever. Okay? I just wanted to bring that up because that just kind of occurred to me earlier. Like, how can your ass be a primary care physician with your child in that school knowing that these injuries have been caused by that device and that you're still pushing for it? Like, if anybody sees that, go through the comments again, find said doctor's name, and if he's your primary care physician, please cancel all your appointments and speak with your insurance companies to maybe find yourselves a new one. Because an individual like that, you can't really trust. I'm just saying. If they want to sue me, tell them to make my day. I am bored, cranky, and I've got about 13 to 14 years of pent-up call center rage just waiting for an outlet. For the love of God, make my day. Just saying. Alright, but yeah, I just wanted to say that because Mother of God. That also being said, but you're not allowing educatory procedure because we've already gone through this process before JRC. As I was saying on yesterday's video, we had all the hearings. You had 6 years to make your case. Within those 6 years, parents came forward on your behalf to testify and toe your party line. You had all that time to bring forth real data. You couldn't, but you were given the time to bring that supports your side on things. Everybody was given an equal amount of time, and in spite of the fact that you continue to play the martyr, everybody was given the same type of objective overview on each side. On each side. Because the FDA did come down hard on a few things coming in from our side, which is expected. The medical model literally paints us as nearly subhuman. I don't agree with it, and I bitched about it, but it also is what it is. You had all the same opportunities that we did to make your case. You failed. You have no new information or data to present. You only have the same crap that you have copied and pasted for over the last several decades. Nobody has time for that. Have you seen things lately? Everything's going to hell in a handbasket. Nobody has time to continue to review the same crap, the same arguments, going over the same evidence forever and ever and ever until the final trumpet sounds and Judgment Day is here. Nobody has that kind of time or patience. So no, there does not need to be another hearing. You were given the same fair shake that we were. The fact of the matter is, you could not make your case because your case is garbage. It's It's lies. It's pseudoscience. It's barbaric and monstrous. There is a reason why literally nobody else who's ever worked in this field has opted to get those types of devices for themselves. And I promise you, I've worked side by side with ARC now for, actually with them it really has been over 20 years, because I started working with them starting about around 2006 when I went up with them and Judavine during the early 2000s when they were trying to make cuts. So yeah, just saying, there's no reason to have more hearings. The JRC has already had 6 years to make their case the same as we did. They have nothing new to present. They have no new data that's going to move things in their direction. It's a completely pointless waste of time and completely just frivolous wasting of trees to force us to go through all of that again. Now, the whole findings particular to those persons and it's individualized. Okay. Let's talk individualized. Most parents, it is their vicinity to take care of discipline in regards to their children when they do stupid things, yes? That's an individualized decision made between the parents, yes? Okay. So if one of those ideas of discipline happens to be like using a stun gun on them for what they did, and then someone calls the cops on them, do you know what's going to happen? Those parents are going to go to jail. In general, parents have the authority in regards to disciplining their children. When that discipline becomes no longer discipline, but abuse, outside forces can then intervene on the behalf of the child to protect them. Correct? Exactly. This is no different. What the parent wants does not supersede the child's right to healthy, safe, and sane medical care and mental health care. Just because they are minors does not mean that they don't have rights too. Alright, we're going to go ahead and read the next part here. Justice Holmes' pithy explanation in bimetallic has set the basic parameters for distinguishing between an education and legislation ever since. A local board had to determine whether, in what amount, and upon whom a tax for paving a street should be levied for special benefits. A relatively small number of persons were concerned, who were exceptionally affected, in each case upon individual grounds. Again, I'm going to need you, JRC, to listen to the words coming out of my mouth. Parents are trusted overall by the state and federal to discipline their children when the situation calls for it. If the decision in regards to what that discipline is going to be crosses over into abuse, such as, I don't know, using a stun gun on them for their misbehavior, to the point, like you guys do with the GED devices, where it causes second and third degree burns. In such situations, it doesn't matter what the parents' rights are in regards to the decisions they make in regards to their children. When it crosses over into abuse, then the state and federal has every single right on planet Earth to step in on the behalf of the child to protect them. And those two parents are going to jail. You understand how this works, right? Parental rights do not supersede the child's rights. When the situation calls for it, the state and federal can and will step in. It doesn't matter that the parents have the authority over their children in those types of situations. The decisions are going to hurt the child. People step in to protect the child. What is there not to get here? It is the easiest, most logical thing in the world. But it's only going to affect a small amount of people, and they're the ones that are going to get hurt by this. They're already getting hurt, you morons. If they are stuck in your human shock collar, they are already getting hurt every single day. You are putting young kids in a human shock collar with a concentrated amount of electricity shooting through them that is literally just below the lethal limit. There are 250-pound PCP high men who run like the devil that can be knocked the hell out by a police taser or stun gun. The weakest charge from one of your GED devices is 3 times more powerful than that. So yes, in that situation, it doesn't matter whether the parents agree and signed consent or not. In that case, it doesn't even matter that the Massachusetts courts agreed with you. What matters is we can prove abuse. We can because there's ER documentation to prove it. There is video surveillance footage to prove it. There is ER photos to prove it. There's nothing to argue here. Okay? And on that, folks, we're going to go ahead and close out. We don't get very many views on this channel, and the few we do tend to get removed from time to time. So, folks, if you could, please don't forget to hit the like button, hit subscribe, and please, folks, don't forget to hit the comments. I absolutely do appreciate your time, and as always, folks, we here at Spilling Tea absolutely do hope you have a good one. I'll see you all here in a few seconds. Bye-bye, everyone.